Faces, their faces.
All rise. The Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable Joseph Boatwright, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to the 5th District Court of Appeal oral arguments located this morning here in Putnam County. And we thank the county for having us this morning. Before we get started, let me introduce the judges on our panel. I am Judge Boatwright. To my right is Judge Scott Makar, and to my left is Judge John McIver. We do have some school groups this morning here with us, and thank you for being here. And when we get finished at the end of the docket, we'll try to leave some room for them to ask questions. Also, if you could at this time, please silence your cell phone or other device at this time, and that would be greatly appreciated. Now, we have 2 cases on the docket this morning. Each side will have 20 minutes to make their argument. Appellant is allowed time for rebuttal, so when appellant comes forward, please let us know how much time you would like. Our first case is case number 24-2352, Brown & Brown of Florida versus Hooligans Pub and Club. And so is the appellant ready?
Yes, Your Honor.
Okay.
May it please the court, Melissa Murphy on behalf of Brown & Brown of Florida, along with my colleague Quake Prindle and client representative Michael Caney, litigation counsel. I'd like to reserve 5 minutes for rebuttal. Thank you. Brown & Brown is an insurance broker. It's not an insurance carrier or risk bearer. That distinction makes a difference, and it's important. An insurance broker is not the de facto insurer of every uninsured loss of its client. The trial court erred in creating this standard by failing to direct the verdict in favor of Brown & Brown, and instead the jury returned a verdict for Hooligans where there was no evidence of causation or damages. The trial court relieved Hooligans of its burden and obligation under Florida law to put forth evidence of an insurance policy that was available to Hooligans at the time of the loss that would have responded to the damages Hooligans requested at trial. The only insurance policy Hooligans presented at trial was the Lloyd's insurance policy. It's the very policy the coverage court determined did not provide coverage for the loss Hooligans suffered because of 2 specific exclusions: a microorganism.
If I could ask a quick question.
Yes, Your Honor.
I'm sorry to interrupt. You had 3 causes of action.
Yes,
The jury found for your client on the first negligent or
correct.
And if they had found liability, then that case, the Capel case, would definitely apply because there wasn't any evidence of a policy able to be procured, right? But the other 2 counts, breach of fiduciary duty and negligent misrepresentation, are different. They're different types of claims. And as I understand it, there is no precedent in the state of Florida, no case that says definitively what the damages should be in this context for those 2 claims. So this is a case of first impression as to those 2 damage issues, correct?
Yes, Your Honor.
And you're asking us to
Correct.
follow the analysis that applies for negligent failure to procure
Yes.
the damage analysis.
Yes, following Capel, and there are 2 more recent cases in the AAA cap funding case and the Florida Caverns case, one out of the 3rd DCA, one out of the 1st DCA. But it's a little more nuanced, and it's probably because of the facts at issue here. And that gets us right into the first issue on appeal, and that's the directed verdict issue. And that we asked the court to reverse because the trial court failed to direct the verdict in favor of Brown & Brown on causation and damages. We look at Capel, and then it's progeny, because Capel is a very short case about a flood policy, and there's much more analysis in the AAA case, in the Florida Caverns case that followed. There are 2 steps. 1,
But negligent procurement is different from misrepresentation and breach of fiduciary duty, correct?
yes, but not in this context. You have to go back to the pleadings. So the amended complaint in this case.
Let me ask you this. For failure to procure, the damages is the difference between the policy you would have got and the fact that you didn't have it. what it would have paid and what you wanted to get. And I guess for the negligent or misrepresentation, what is the damage mechanism? What causes damages when you fail to properly advise on what the policy covers? Is it the fact that you didn't go get another policy?
It could be, and the Fifth DCA in March of 2024 gave a very good example of what it could be in the ENR case. It's a summary judgment case, so a very different posture than we had a full trial in this case. In that case, it was a liability policy, and the court there said, had the insured known that there was no coverage, they could have removed, it was an indemnification provision that was at issue, could have, for example, removed the indemnification provision, and then perhaps gotten coverage. But the court said at summary judgment, disputed issue, material fact, and they said, we don't know, we need to go to trial, and the jury will decide those issues. Here, though, what's really important are two things. The pleadings in this case, the amended complaint, brings 3 causes of action. All of the exact same facts are incorporated into all 3 causes of action, and the probably most important, Hooligans asked for the same measure of damages in each cause of action, and specifically takes the language, pulls it from Capel, and asks for the loss of coverage that they had expected had the insurance sought been properly obtained, including leasehold improvements, business, personal property. So Hooligans, that's the pleading that was our guide at trial, and at closing argument, Hooligans asked the jury to award it only damages under the Lloyd's policy. One unified theory of damages. There were no additional reliance damages put forth whatsoever at trial. So the jury predictably returned a verdict following the sublimits of the Lloyd's policy, a policy that could not have provided coverage.
Well, what would the theory of causation there be then? You told me that the policy covered this, the policy didn't cover this. So where does the damage come from in that? What's your causation? Explain your opponent's theory of causation under the Lloyd's policy.
That policy existed, they thought they had coverage under it, therefore they get the policy limits. That was the only theory, my recollection at trial, that was advanced. They didn't need to follow Capel, they had this policy. That was it. They asked the jury to award coverage strictly under the policy, and they did so. The problem with that is it defies logic, and we see that in how the jury returned its verdict.
Did they raise any issue below about the flood insurance and that would have covered their damage, the policy for flood insurance? Because that seems to be the main issue here on appeal.
I would disagree that it's the main issue.
Well, that's their argument as to damages, correct?
Part of their
arguments.
One of their arguments. So let me speak to the flood policy for a moment. The discussion at trial was perhaps there was a flood policy available under the National Flood Program. In the record, the federal statute that the flood policy comes from is in the record. However, there is no testimony from anyone that would have been available to Hooligans in 2016, 2017.
Was there a policy entered into evidence?
No, not a policy in that sense, Your Honor.
If there had been an exemplar policy put before the jury that showed, hey, here's a policy that would have covered this, didn't have all these exceptions, wasn't 5 times the cost of what you're insuring, so you probably would have procured it, then would we be here today?
We would still be here because there's a second part to the analysis. So step 1, you need to enter into evidence either a policy or expert testimony that a policy could have been procured. Step 2, you need to show that the damages you're claiming would have been paid out under that policy. And for flood policy, unfortunately in Florida we're all very familiar with this, the damages paid out under a flood policy are very different. For example, business interruption is not one of the coverages available under the National Flood Program, which is the statute that's was
that presented below? Was that argued below in the testimony?
The business interruption, Your Honor? No, and they did not, but Hooligans asked for business interruption at closing argument, and that was in the Lloyd's policy, and they proceeded to do that. Now, one of their damages experts testified to that business interruption was one of their components of damages. They put on 4 experts, 3 on damages. All of them testified that the damage numbers presented were not based on what an insurance policy would have provided coverage for. And that's in the trial transcript at 487, 398, and 533. So it was untethered even from the Lloyd's policy, the damages. So we have 2 components. The causation issue, that there's no policy that was available to hooligans at the time that would have covered the loss. 2, even if there had been, they didn't prove the damages under the policy. Both expert witnesses testified this way. Brown's expert, and as well as Hooligan's expert, testified that there was no available policy that would have responded due to these 2 standard exclusions in the policy. I'd also like to point out that Florida's standard jury instructions on legal cause for negligence, breach of fiduciary duty, and negligent misrepresentation all speak to but-for causation. They are the exact same. Those were the jury instructions the trial court read to the jury. So irrespective of the cause of action, because our jury instructions, and it's a common law tort, require but-for causation, there should be no difference in how the court views the 3 causes of action, because hooligans asked for the same damages under each one. It could be different had they pleaded and then put on evidence at trial of different damages. The first time hooligans advanced this argument of other damages was on appeal in their answer brief, not post-trial, but on appeal here. So for all of those reasons, the failure to prove causation and damages, we ask the court to reverse and instruct the trial court to enter judgment for Brown and Brown. Now, there's a second issue, and that is in the alternative, and it's a request for new trial.
What would be the damages? Your client was found to have misrepresented negligently and to have breached fiduciary duties, so they don't have any consequences of that?
They do not. They're not an insurance carrier. Mr. Curtis, Hooligan's representative.
But you're not here saying they were improperly sued under those 2 counts. At this point, you acknowledge those are valid causes of action against your client.
They are valid causes of action. They're causes of action that our Florida case law discusses in great detail.
And they breached those duties, and the only question today is the measure of damages or causation.
There was a lot of, I'm sorry, let me answer your question. Brown and Brown's position has been they did not breach those duties. Those were hotly contested factual issues at trial. The jury's verdict found that they did. Our argument is that there's no causation if the breach occurred. Assuming hypothetically the breach occurred, there's no causation or damages.
But that's fine. But this case today, you have to acknowledge, accept, concede that there's a jury determination that there was a duty and that it was breached.
Yes.
You have not raised an issue on appeal saying there's no such claim. I know that Mika's threw it in, but
We have not raised that issue on appeal. We are focused on the causation, the link between breach, causation, and damages.
Well, and just to clarify, you are contesting the failure to issue a directed verdict, so you do actually contest the jury's finding.
We contest the ultimate finding, yes, Your Honor, just breaking down the elements of the claims. We're focused on the appeal on the causation and damages issues, as the Florida case law between Capel, AAA, and Florida Caverns indicates that I think compels, obviously this court will determine that one way or another, the result here that because Hooligan sought the damages under the insurance policy that it thought it had, the measure of damages here is what would that policy have.
Hooligans had damages, though.
Hooligans did have
Okay,
damages.
so if the jury found there was a breach, how is there not causation, some type of causation that caused damages? Now, maybe you're correct on your damages argument, but I'm still unclear how you don't have causation at that point unless the jury finds a breach.
So we look to the but for. Assuming Brown and Brown breached its duty to Hooligans, If it could not have procured a policy, though, that would have responded to the damages at all, it breaks the causal chain. And that the court talked about this in that AAA cap funding case where they said, there are damages here. The house was destroyed by Hurricane Irma. It's a very harsh result, but it was not an insurance broker, it was a mortgage broker, but they analogized the negligent hiring to negligence against a broker in that instance. And there they said the plaintiff didn't come forward with evidence of a policy. So the problem here is there's no causation and then ultimately damages, and they are they are linked together here. Capel starts with the damages component, assuming, all three. Let's say you had duty, breach, causation, and Capel says that you didn't prove damages. Here, Hooligans had damages, but they have to prove those damages under an insurance policy that would have provided coverage for them. Your insurance broker, and I know that the amicus speaks to these issues, is
or
not,
evidence that an insurance policy likely would have existed.
yes, via expert testimony and an expert that's been in the industry.
That Hooligans would have purchased, but for the misrepresentation.
Right, in that there would have been a policy available. Or testimony. Hooligans had the opportunity at trial to testify as to what they would have done differently. The 50 CA's E&R case was published a month before that trial. We discussed it at summary judgment. We discussed that case at pre-trial, and Hooligans put on no evidence of anything they would have done differently or relied on that then those damages would flow separate and apart from the insurance policy. I'm going to use the remainder of my time for rebuttal. Thank you.
May it please the court. My name is David Bucalja. I'm the attorney for the plaintiff appellees in this matter, Hooligans and Woman Blind. Hooligans brought this claim against Brown & Brown, alleging 3 claims: negligent failure to procure insurance, breach of fiduciary duty, and negligent misrepresentation. This case arose, the facts occurred a little over 9 years ago, when Mr. Curtis consulted his insurance agent at Brown & Brown, Mr. Tallon, seeking to renew his property and casualty policy. Mr. Curtis, and this is all in evidence, Mr. Curtis emphasized that he wanted hurricane coverage, period. Mr. Tallon knew Mr. Curtis long enough and was experienced enough with Mr. Curtis long enough to know exactly what he meant. And Mr. Tallon reported back that he found such a policy. He found a policy with Lloyd's. He went on to explain to Mr. Curtis this policy with Lloyd's had a named storm endorsement, and this named storm endorsement provided, quote, enhanced coverage. Those were Mr. Tallon's words. This is the broker. This is the agent to Mr. Curtis. And the named storm endorsement supposedly provided coverage for any object, material, debris moved in any fashion by a named storm, that being a hurricane. Mr. Tallon assured Mr. Curtis this was better than the standard policy. This was provided more coverage than the standard policy. With that, we bought the policy. Almost 9 years to the day now, Hurricane Matthew struck the Ormond Beach area, caused a lot of damage, massive flooding. Power went down, out for days. Over the days that followed, as all the water settled to the lowest spots, all of a sudden the shopping center that Hooligans is located in is flooded. The entire shopping center, the parking lot, the units, as well as the back area, all flooded, as well as the streets out front. A lot of the water came up through the drains, which included stormwater and sewage, because the lift stations were down, and none of that stuff was going anywhere. It comes up through the drains. Mr. Curtis is assured he has coverage. We submit a claim to Lloyd's. Lloyd says no coverage. You've got exclusions here. You've got sewage backup. You've got sewer backup exclusions.
You contend that Capel does not bind us for negligent misrepresentation.
Yes, sir.
What is the appropriate measure of damages for negligent misrepresentation? What harm is done when someone relies on someone's negligent misrepresentation?
Mr. Curtis does not, and this is actually addressed in one of the cases that's cited in the brief, explore what alternatives may be available to him to provide the coverage he wants had he been properly counseled on what he lacked. And for example, Mr. Tallon, the agent, to his credit, testified very candidly that he regretted not having recommended a flood policy. That's where the whole conversation regarding the flood policy starts. So we have Mr. Tallon as the agent working for Brown and Brown, admitting in his testimony that he regretted not providing a flood policy, basically admitting that, and of course he acknowledged after the coverage court.
So your position then would be because he did not have the opportunity to seek alternatives, that the jury should presume that alternatives did exist?
Well, he wasn't educated as to what alternatives there may be. He thought he had everything he needed.
If there was no other insurance policy in the world that would have covered what he was, and I realize this is talking in the
Yes, sir.
extreme, one example, but if no insurance policy existed that would have provided the coverage that he needed, would the measure of damages for the negligent misrepresentation still be the same? If he couldn't get any other policy, he didn't have the opportunity to seek it out, but if he had the opportunity to seek it out and it just wasn't out there, he would have suffered the same damage, right?
He would have suffered the same damage. He bought a policy providing coverages, negotiated with Mr. Collin. His bargain for expectation was he was going to have these coverages and that these coverages were available.
So then ultimately my question is, although Capel may not have applied to negligent misrepresentation, why isn't the reasoning of Capel for the measure of damages exactly the same?
Because the measure of damages, if I'm not mistaken, the negligence action is reasonable compensation for the loss incurred as determined by the trier of fact. And I think my response to your question is reasonable compensation in the context of this action would have been what the reasonable expectation Mr. Curtis had with regard to the
Reasonable
coverage.
compensation for the loss incurred or reasonable compensation for the loss caused by the defendant?
Well, it would be for the losses caused, but the measure of those damages, for example, we had $2 million worth of building damage. We didn't seek $2 million worth of building damages. We saw a reduced amount predicated on the sublimit because we couldn't say with a straight face we entered into this transaction asking for $2 million worth of building damage. So we didn't perceive that as being the measure of our damages, notwithstanding that we were suing for breach of fiduciary duty, and notwithstanding that we were suing for negligent misrepresentation. The fact of the matter is those two remedies still arise in the context of this transaction that we were a part of.
But the negligent misrepresentation didn't cause the seepage, didn't cause the damage of the property, it caused the lack of coverage.
Yes, sir.
Arguably, it caused the
Yes.
lack of coverage
Yes,
if coverage was available.
Yes, sir.
Capel says you have to show what coverage was available.
Bell says you have to show coverage is available in a negligent procurement claim. This is not a negligent
And my
procurement.
question was, why is it, and why is the reasoning any different at all?
Why is the reasoning as to the measure of damages any different?
Right.
Because the remedy we're looking for now is negligent misrepresentation. Whatever damages are available there emanate from negligence law, and the negligence instruction we had was.
We just had an entire conversation about how the damage that is caused by the negligent misrepresentation is the lack of coverage.
The loss of
Not the
coverage.
damage, not the seepage, but the fact that you didn't have coverage for that loss.
Well, it wasn't just a lack of coverage. It was the loss of coverage that we reasonably anticipated, which had already been quantified. It wasn't just, a nebulous amount of money out there for us to try to rationalize what chunk of it we may be entitled to. It was the loss of the coverage we actually expected when we entered into this transaction. That's all part of the context. Otherwise,
You didn't lose that coverage. The court found you didn't have that coverage to begin with. You thought you did.
We thought we
You
did.
relied on that thought to not go get other coverage.
And pay
It's
for
the
it.
lack of the other coverage that is your damage.
I'm sorry, what now?
It's the lack of the other coverage that is the causation of your damage.
Well, it's the lack of the other coverage that's the cause of the damage. I guess I would respectfully disagree because I'm not understanding how we lost what we bargained for because our broker sold us something that didn't exist. I would sit there, I would think that the recourse in that context would be whatever we reasonably relied upon, that the broker had told us as far as what our coverage would be, that would quantify the loss, as opposed to just speculating or just coming in saying, okay, we're entitled to damages for everything we lost, which was significantly more than the sublimits that were involved in this policy that we got into to begin with. But I guess the answer to my question is, I don't see how the broker can take advantage of the absence of a policy when he sold us a non-existing coverage. I would argue that's the essence of
It's
fraud
taking
action.
advantage of the non-existent policy. I mean, I realize in my hypothetical, I said, what if no other policy existed? But actually, the issue before us is that your client, or you failed to present to the jury what another policy would look like.
We did not present what another policy would look like. The testimony was that there was a flood policy available, and a flood policy did provide coverage for sewage backup. So the expert testimony provided at trial acknowledged and corroborated what our agent had already told us about the existence of, about how he had regretted not getting a flood policy. The expert testimony at trial, actually Brown & Brown's expert, confirmed, yes, there is a flood policy, yes, they are available, and yes, they provide coverage. I believe they testified they provided coverage for property loss. I don't believe they got into lost income. And yes, those a flood policy would have provided coverage for sewage backup. So that exception that the coverage court relied upon in denying us coverage would not have applied to a flood policy. And we have Mr. Collins, our agent, at the outset of the litigation, acknowledging that a flood insurance policy was an alternative he should have gotten into with the client, but he didn't. So that flood insurance policy is one example. I don't know that the absence of the policy applies to the breach of fiduciary duty claim. I don't know that the absence of the policy applies to the fraudulent misrepresentation claim. Counsel here in their argument couches the entire presentation in anticipation that Capel somehow is the overview that everyone utilizes to analyze these claims. I would respectfully disagree with that. The counsel was insistent, or persistent rather, during the course of the trial, that the court adopt Capel as far as all three claims. And the judge quite candidly stated right out, I don't see me extending Capel to all three of these claims. That's all there was to it. So with that, they did not get their instruction on Capel. They did not get their verdict form on Capel. They were allowed to argue to the jury Capel. They were allowed to argue everything about the availability of policy and the absence of policies. And at the end of the day, when it was all submitted to the jury said, okay, no negligent procurement. Whether they were persuaded by their argument or not, I don't know. But they also were presented with the breach of fiduciary duty and negligent misrepresentation, which were distinctively different claims. They found for us on that, presumably in large part on the basis of the testimony presented, particularly by Brown & Brown's own agent, Mr. Collins, who acknowledged that he, I'm not trying to be cavalier here, got me insured into the policy, assured it was going to do all sorts of great things for him. Turned out not to be the case. And then after the fact, mentioned that, well, gosh, maybe there was an alternative policy that we should have gotten into. So at the end of the day, I would respectfully submit that Capel, as far as its impact on causation and whatever impact it may have on damages, was submitted to the jury for their consideration, and the negligent procurement claim was denied.
Does the jury make those legal determinations?
I don't know if they made those legal determinations, but the law regarding Capel was presented to them by way of counsel, arguing throughout, and the judge gave them free rein to say, you can argue it all you want, but I'm not instructing this jury from the bench that there has to be an available policy that governs all three of these claims. So they were allowed to argue that. The last point I would like to make is that as far as this appeal is concerned, I don't think I'm overstating it when I say I see very little direct attack on the evidence of breach of fiduciary duty or the evidence of fraudulent misrepresentation. Everything, once again, appears to be all in the context of how Capel is this overarching rule that should be extended to those actions. But that specifically was not the case. That was not Judge Craig's determination. That is not the law. There are no cases extending Capel into the realm of breach of fiduciary duty. No cases that I'm aware of extending it into the realm of negligent misrepresentation. And so with that, I would respectfully submit that it was all properly presented to the jury. There was no error there. And that's about all I have to say, unless you all have any questions. Any more questions you'd like me to answer, I'm happy to do so.
We'll see. Thank you, sir.
Thank you, Your Honor.
Any rebuttal?
Thank you. On the issue of the flood policy, we respectfully disagree that the record demonstrates that there was an available policy in evidence. Certainly, you have to first prove there was a flood. We don't agree with the characterization in the answer brief of the testimony, but there was no.
at least a conflict in the testimony as to whether or not, did the water come through the front doors? I saw some
No.
discussion of that in the,
It all came up
the
through,
sewer
in
system.
Hurricane Matthew, most of us experienced Hurricane Matthew. If you lived on the east coast of Florida, it was mainly a windstorm event. It never made landfall, and there was, to our knowledge, no finding that a flood existed in that area. So step one. Step two, the federal statute is what was put into evidence. We disagree with the characterization of the testimony of Mr. Winans. And three, there was no discussion as to how the damages that hooligans incurred would have been paid out under a flood policy. The jury didn't hear about flood limits, right, which are $500,000 for a commercial policy. They're very different than the Lloyd's policy, for example. None of that was presented to the jury. Going back to the negligent misrepresentation claim and the breach of fiduciary duty claim, ultimately here, Mr. Curtis didn't explore other options because his testimony is that none of this was foreseeable and that he didn't even buy flood insurance or any insurance after the fact that would have responded to the sewer backup. So not only did they fail to put on evidence of something hooligans would have done differently had they known there was no coverage, they actually said, we didn't do anything differently after the fact.
Well, how would that matter?
It just goes, it matters at trial, it mattered because part of the arguments for that, this should have been foreseen. And testimony from hooligans, it wasn't a foreseeable event. But ultimately, the burden of proof here is on hooligans to come forward with testimony or an expert to say, yes, you could have gotten other coverage, but they didn't, and they didn't do that. And the trial court failed to direct the verdict for Brown & Brown on those issues. If Capel and its progeny don't apply, we have to ask ourselves, what's the measure of damages in these cases then? Where there's no other evidence of reliance and damages
Would it
flowing
be what
from
you
that.
paid for the policy? Would that be the-
It could be, and that's actually a note I wrote on the top of my legal pad here. It could be the
What was the
premium.
cost of the policy?
Probably, I don't remember right now. I'd have to actually look at the deck page. I don't recall off the top of my
That's
head.
okay. That's okay.
Probably tens of thousands of dollars. Yes, that could be a measure of damages. And the court in the AAA cap funding case actually said that. Said if they were seeking the return of the premium, that is an appropriate measure of damages here, without putting into evidence what insurance would have been available. So we have to ask ourselves that question. Now, in a different case, like the ENR case, where you could do something different, like remove an indemnification provision and would have had coverage, well, that's an entirely different set of facts and damages. But
If we hold that Capel applies to the other two claims, you take the position that we should reverse and have judgment entered. But it's basically a change of the law, because there's no case that says Capel applies. Why wouldn't we just have a retrial on damages?
I do not think it's a change in law. I think it follows long.
But there's no case.
Correct. Yes, but here's why. Because they are three common law tort claims that all require causation and damages. There's nothing different about the but-for causation instruction, the jury instruction, that should be changed. It's still proximate cause but-for causation and damages linked to that. So that's why we believe that the court should enter judgment for Brown & Brown. We have alternatively asked for a new trial on these issues, mainly due to the failure to instruct the jury in the verdict form. The very first question was an interrogatory verdict form. Was there available insurance policy? If your answer is no, then your verdict is for Brown & Brown. The court declined to put that on the verdict form. And those are the reasons we've asked for a new trial. We have two other arguments. The court, they're in our papers. They're on Remediator as an alternative argument, and there's a prejudgment interest issue that doesn't require reversal, but it's de novo standard of review. that relates to accrual of causes of action. So for all those reasons, we ask the court to reverse, enter judgment for Brown and Brown, and in the alternative, direct a new trial.
Thank you.
Thank you.
Thank you. Very well argued case.